very much about what we should do in these cases. The West Bengal cases are pending before the Supreme Court. So T. Roy has filed that case where about 300, 400 persons have been killed. And if you look at those cases that we have filed, like the case you had here of trafficking, torture, killing, shooting in cold blood, it makes you think that maybe there's no hope for this country really. In every single case, the defense of the BSF is that the person raced towards the BSF platoon. Can you imagine you have a BSF crew of about 5 or 10 people fully armed, and this so-called smuggler or whatever is racing towards this platoon with a sickle or some other implement of agriculture, and then they are shot dead. No FIR is registered, no case is registered, and when the cases are registered, the orders are there, sir, of the magistrates' courts, that these cases are not maintainable in the civilian courts. It must go to the, I think it's called the security courts. Under the Act, it's called the security courts and so on. So clear impunity in hundreds of cases, not just a few cases here and there, hundreds of cases of impunity. And complaints pending with various bodies for 10 years, 15 years and so on. So it's obvious that when the BSF man acts as in the case of this girl, that they really don't care. Raping and killing is part of their normal nature, they really don't care. If you look at the Manipur cases where the widows of the disappeared filed this case on behalf of 1,350 persons who were disappeared. Meticulous documentation. Eyewitness accounts, so you can't even say that there's some doubt as to this case. There are eyewitness accounts in terms of, mothers and wives and family friends and so on, who saw the abduction from their house. In Javit's case, in the Lodhi Road boys case, they saw the actual killing. They took him while he was reading the newspaper at home, in front of his family, 12-year-old boy, dragged him to the garden and shot him dead. And in all the Manipur cases, standard form answer, that he was a militant and he had a 9mm pistol. So in all the 1,300 cases, you will find a 9mm pistol near the body of the person. If you look at the post-mortem reports, this is again a failure of our entire medical system when it comes to post-mortems. If you look at the post-mortem reports, you'll see every single case, the post-mortem report, says bullet wound, etc., and you will get nothing from the post-mortem report which will indicate torture. So there's breakdown. So there's no need to go looking at these post-mortem reports because they are virtually worthless pieces of documents. The ballistic reports rarely come or they come very late and so on and so forth. To their credit, this commission appointed by the Supreme Court, that is headed by Justice Hegde, with Lindo and DGP Kumar, this 3-person inquiry commission. What an extraordinary commission. What an extraordinary commission. They sat, no nonsense, no list, looking at records, issuing notice, waiting for reply, nothing, no nonsense. We are hearing this matter, we are fixing a date, army officers come. Right? And the NHRC can do this, Mr. Paul. There's no need to go. The process you will follow is a completely laborious, lethargic and typical judicial procedure for which nothing will come. We have to learn from this lesson. Fix a date. All the army officers who are involved with these encounters shall remain present. Army officers take an oath, stand in the witness box, you are cross-examined. You will only get evidence of false fake encounters from the cross-examination of army officers. Very many cases. Because in many cases there are no eyewitnesses, so it's word against word. They stepped in the witness box. What a marvelous experience. I'll just be very brief, but I'll tell you, what a marvelous experience. I remember this major stepped into the witness box. Typical story. They came towards us. We said stop. They took out their weapons, shot at us and ran. We returned fire. One person dies, 9mm pistol, one person runs away. Classic answer. One person must always run away. You must understand why. Because then in the first information report, there's a blank, person unknown kept in the first information report. Which means any innocent person caught 5 years later, 7 years later, his name is inserted in the FIR and that person is looked into the case. Anyway, typical case. So they step in the witness box. Never before, I think never before have army officers have been told to get into the witness box and face cross-examination. Mukul Sinha came from Ahmedabad, I did 1 or 2 cross-examinations. So, sir, this is a dreaded terrorist. Yes. And sir, you are sure he was a dreaded terrorist? Yes. Which outfit? He named the outfit. Sir, you have a list of terrorists in your state? Yes. You've seen that list? No. Anybody in the army has seen that list? No. Can you produce the list? No. Do you know where the list is? No. Then why did you say he was a terrorist? Sir, he was coming from so-and-so village. And? Sir, that village is full of terrorists. This is just one cross-examination. You should see the rest. You should see the evidence that comes straight. And Mr. Paul, this is a lesson for NHRA. You don't have to sit in benches of twos. If you find that there is dissatisfaction in the country, even you singly can decide, there's no problem. It's just a matter of rule making and do it. Put them in the witness box when an allegation is made of fake encounter, particularly when there's a witness. All our eyewitnesses came and gave straightforward testimony. He was taken in front of me, they were in uniform, they pushed me aside, they took my son. 2 days later he was found dead. Clear cut. You cross-examine a person who's a genuine witness and more truths come out. And it flows like a volcano. And then when these guys come in with all their fabricated stories, they get completely caught up in a good cross-examination. Completely caught up. That is why Justice Hegde's commission said, within a period of 3 weeks, 3 weeks, and that too they had to go to Manipur and all that all the 6 or 7 encounter cases that they took up were fake encounters. All the persons killed were not dreaded terrorists. They were supposed to be all dreaded terrorists. In fact, they concluded they had no previous criminal record. But that is the state of the country. I don't know really what we are going to do. I don't know. I have seen no hope actually. Deep frustration and no hope. Our judicial system, let me tell you, is also now gone. Completely gone. And there are, maybe a handful of judges at the highest level in the high courts who will even listen to these cases. In the conflict states like Chhattisgarh and so on, it is impossible. It's amazing. These courts, as constitutional courts, they can close down. I can say in front of the camera, you can close down the constitutional courts. Just give them appellate powers for property matters. You do your property matters, you do your tax matters, you do your other petty matters. As far as protection of human rights is concerned, the laws of the Chhattisgarh High Court are closed, Jharkhand High Court are closed, Odisha High Court is closed. All these high courts are closed to the people of India. You can be tortured, anything can happen to these laws. In the Supreme Court also it's becoming very difficult, it's becoming very hard. There are some extraordinary judges who take up, but there are not many. And in the country, basically, I think the judiciary is now sort of not very keen, not interested in taking up these cases. As far as this is concerned, sir, with this I'll stop. As far as these witnesses are concerned, my request is, I told Kirtida we'll do it right away. We'll take them to the office, we'll take their signatures, we'll take their wakalatnamas today, we'll do a separate case for these 6 people, right away. We'll file a separate case for these 6 people. If you don't mind during lunchtime or something, our lawyer is there, just take them, right? Take their affidavits, wakalatnamas, the stories are all here. And we'll file a separate case for these 6 people in the Supreme Court straight away. Asking for punishment, asking for some kind of investigation and so on. I don't know what else to do. Really, as a lawyer, I don't know what else to do. And of course, if the NHRC reports come in saying that it will strengthen our case immediately, I want to renew my request. In all these cases in the Supreme Court, if it's possible that we can have some kind of a collaboration. And if the level of the intervention in Supreme Court can be heightened, quite heightened, Because what happens is that generally at this level that we lay down guidelines and those guidelines are not being followed and so on. And so now I tell you in this country guidelines are not going to be followed. Supreme Court guidelines are not followed. Why should NHRC guidelines be followed and so on? We have to take a more combative approach to these misdeeds by security forces and the army. And Section 19, sir, again, have a close look. Section 19 does not prevent you from carrying on a complete investigation. It will prevent you from taking action. I mean, you can't take directions and actions. But in my opinion, after I've seen Section 19, we will argue that before the court. There is nothing which prevents you but have a full-fledged inquiry. Full-fledged inquiry, and they cannot tell you that we will not participate. And more than that, the power of the NHRC to do a case. You can just say, all right, this is a case, it's a troublesome case, let's take it up. And sir, we'll give you free of cost, don't worry about payment, we'll give you in the Supreme Courts, in the High Courts, we'll give you any number of lawyers of standing in the High Court, or not just there are some people here and there, but of standing, who will say, all right, we'll take up, it's a prestige thing to handle an NHRC or SHRC case. So anything where you find your hands tied, we can straight away go and do these cases on behalf of NHRC as the mandate is. We have to shake the cycle of inactivity from our side and the cycle of ineffectiveness from our side. We are completely, civil society has become completely ineffective. We are reduced to fact-finding reports, press conferences, fact-finding reports, press conferences. We have to break it somehow. We don't know how to break it. I don't know how to break it. Thank you very much.
Follows response.
I don't want to respond. Sir, absolutely can interrupt. I can. I just wanted to say. Not I think the first debates with others are very unfortunately on section 19. Because, as I said, I'm not lawyer, I have the exception in the Commission of Law and Legal Background. In the view of those who have been before us and those who are now there, legal background, because it says notwithstanding anything else which lays down our quasi-judicial powers. Here, our powers are central and limited to our being able to ask the central government to furnish a report. Now, to interpret that to mean that furnishing a report includes having the officers concerned appear before us to testify under oath, I think in the view of our board members is way beyond what we are permitted to do. Let me say we do exactly this on cases involving the police, where we have SPs who have been falsely arrested. They have appeared before us under orders of arrest. Others have simply been summoned. So we exercise these powers to the fullest on civilian police, including not just civilian police against doctors, where we find the post-mortem reports after receiving advice from our forensic specialist, the doctor had deliberately fudged, because one of our guidelines which they comply with is that the autopsy must also be videotaped. And when our